Good morning, good afternoon, good evening, depending on when you're catching this. If you're catching this right now, it is early evening, 4 p.m. Central Standard Time. Well, I didn't want to take up too much time, but I definitely wanted to dive right on in. I hope there's not too much of an echo because I have my fan on. Menopause is another. However, I digress. I wanted to come on here because I got some very interesting phone calls today. Just nothing from nothing bad. Don't calm down, everybody. I got some interesting phone calls today. Just regarding something with me, and it always kind of shocks me and has me in a place where I get how do I describe it? Like I'm kind of okay on the outside, but it really affects my inside. So I had to take a step away from that, make sure I was done with all of that, and here I am. So what I wanted to talk about, because this is something that I've had experience with. I am not a lawyer. Yes, I am not a lawyer, but I do have a lot of experience. Before I even get started, let me put a disclaimer up here. What is this disclaimer? Um, I am not just, because I think that's all people need to know. So let's go. All right, let's show that. All right, I'm not a lawyer, just successful in the field. So I wanted to talk about mandatory mediation. I want to talk a lot about law, and especially when it comes to not only like knowing your rights, but understanding your rights past traffic stops, past, you know, shoplifting or, that sort of thing, whatever. But just beyond the actual whatever is happening, I just wanted to kind of give my own breakdown on mandatory mediations or conciliations, as they are sometimes called. Um, I know that there are different, people have different experiences about or with their mediations, because there are mediations where you have a choice. It's like, do you want to mediate or no? And if the answer is no, you can take that time to figure out what your next steps are. And and if you don't, uh, and that's, I'm sorry, I have to fix that because that was misspelled. I don't know how about misspelling if I can do that. But anyway, so when you have a mandatory mediation, that is a little different than saying, hey, I don't want to do this no more. Either way, we're going to talk about both. So, what exactly is a mandatory mediation? Okay, a mandatory mediation, I kind of look at it like if you're in a maze that has these obstacles and it's a lot of frustrations and dead ends, that's the legal dispute. That's what that maze represents. And instead of like wandering through the maze of trying to come to a conclusion or come to a resolution, I should say, with whomever, the legal dispute. There is this guide, and that guide would be called a mediator. And when it's mandatory, that means that you must consult with the guide before you can even venture further into that whole maze of what litigation, of what litigation is. And we will talk about that in a subsequent video because lots of good stuff here. What is a mandatory mediation? A mandatory mediation is a structured process where the parties involved in a dispute are required by law or court order to attempt to resolve their issues through mediation before proceeding to trial. So, think of it like a stop sign. It's like, okay, here's litigation over here, and then there's this stop sign that's like, or monopoly, like, stop right here, do not collect, go. Do not pass, go, do not collect $200. So, and that's to like encourage the parties involved, whether it's a domestic or civil or employment, or, it could be many things, but the mandatory litigation is to encourage parties to kind of try to pause and find common ground. So let's first go into like, why is that important? It could be important for a number of reasons. It's cost effective. Litigation can be like a snowfall, like rolling down a hill, growing larger and more expensive. And mediation, on the other hand, it pretty much reduces costs significantly. And from my experience in saying this, sometimes, not always, I can't say always, I can just say from, what I know to be, is that when we have that cost reduction, it usually means that the litigant or the person that is seeking something is the one who gets those costs reduced significantly. However, if you have a lawyer and they, it's 33%, you could end up getting less, but that's not what we're talking about. Number two, time saving. Like, trials take months, it could take years. Mediation usually provides, solution in days or weeks. Usually they like to make not litigation. Usually they like mediations to, I think it's like 1 day, but that depends on the jurisdiction. And it's kind of like a fast track instead of, going through the litigation process, like, can we settle this, blah, blah, blah. But it's mandatory. So, also you have to remember that whether, because some people think the name mandatory mediation means that you have to come to some type of agreement. You have to do something that you are not wanting to do. And if you're doing that, then how are we doing anything to help? So, see, with that, I definitely wanted to talk about how you're empowered. Like, you have power, you have control, and I'm talking about both parties. So In mediation, the parties retain control over the outcome. It's like you're the director, this is your play, you're not an actor, you're the one that's doing the collaboration to create a resolution. So that's that part of uh, mediation, remembering that it is not a mediation is not something that is, you're supposed to feel pressure about. It's not something that you are supposed to feel like, oh my goodness, I have to do this. And a mediator, if you happen to go into mediation, a mediation shouldn't feel like that. And it's also, sometimes about relationships. Sometimes we do know the people, sometimes we don't know the people. But in disputes, I know we're just going to say where the parties have like ongoing relationships, maybe family matters, maybe business partnerships, mediation, that can kind of help maintain those ties, without, everybody going crazy, like let's all come to some kind of settlement because, we're family, we're friends, we're business partners, we are whatever. So that I would encourage, mandatory mediation for, for things such as that. And again, I'm sorry. If you're my fan, it has to be a certain temperature. But let's talk about what mandatory mediation is supposed to serve as. It should serve as a bridge over, legal disputes, trying to encourage dialogue and cooperation instead of adversarial conflict. So, when you come to mediation, you got to make sure that you already have goals, I should say your end goal. What is it that you want to get out of this? And you have to see them as opportunities for collaboration and growth. That's like one of the main things about mediation. And then I want to talk. Well, actually, I don't want to talk. I want to take a moment now to pull up a video from an actual attorney about mandatory mediation. And before I pull that up, I do want to say, please hit the like button. Please hit the subscribe button. I don't know if you just got here. I was on private. I don't put it on public. I don't know what's happening. But whoever this is meant to reach, it will reach. So let me see what else. Housekeeping. Be respectful in the comment section. What else? What else? If you would like to donate to Choose Compassion, we are a 501(c)(3). All donations are money back when you make a donation to an actual organization that is doing voluntary work for building communities. But now, let's hear more about mediators from an actual attorney. Now, again, before I do that, I want to say that good mediators, whether it's mandatory or not, good mediators have both parties coming out feeling like, well, I'm really not happy, but it's, it is what it is. Bad mediators, how do you know how to even look for them? So this is where one of the people that actually was so helpful in my journey, just I guess that's all I should say about that, because story time later. But someone that was so helpful for me in my journey in talking about um, or in learning about mediators and the conciliation process, the pro se litigation process, deposition, discovery. It was the job attorney Vincent White. So, without further ado, I am going to um, hear from him, and I might interrupt because I don't want to get distracted or anything. But we'll probably have some conversation. Let's see.
Generally speaking, mediation's a lot more complex than fighting with people. It's much easier to win a fight than it is to reach a compromise, frankly. So, note to all the would-be mediators out there, it's a tough game. It's a tough and complex game. If you want to get into it, go in knowing that. All right, so bad mediators. Here's what's going to happen. They are going to get a big conference room and try to get all the parties in the big conference room. So you're going to have attorneys from the defendants, attorneys from the plaintiff, the defendant, at least a representative from the defendant, hopefully someone with some decision-making authority. There's a good chance whoever comes from the defendant will have a certain amount of cash that they can play with to get the case settled. And then later on, they might be like, oh, I've exceeded my authority. I need to call my employer and see if I can go higher. That's a whole interplay that goes on routinely. There might, in some rare cases, be an insurance adjuster who can throw money from an insurance policy towards getting the case settled as well, although often in our field, insurance companies declaim because many of the things that we are litigating are intentional acts. So it's hard in most policies, not all, but in most, it's hard to say, we offer insurance for hate crimes in the workplace.
And this is employment attorney. I mean, I'm talking about right now, but we're going to go into the actual mediation and.
I've been racist on accident. That's not the only accident is that what lived in their heart slipped out. They were like, oh, the timing of my racism was poor. Too many witnesses, right? That's the accident. So these are often intentional acts. These are choices. And often insurance companies will be like, thanks for paying insurance premiums, employer, but we out because you got bad employees, right? And they're just not going to pay. And the employer's not going to have a ton of luck under most policies getting them to pay. But you could have an insurance adjuster there. Certainly, I have seen it on many occasions. And the mediator is going to ask the parties, not the attorneys, to speak. Often, that's what bad mediators do. And part of what they're doing is they're trying to do two things. One, they're trying to make the defendant feel uncomfortable. Whoever's the representative doesn't really want to talk because at the end of the day, the representative who shows up is probably not the business owner and also probably not the person who did the bad things. So they're there with money to get the case settled, probably not thrilled to be the representative of the company that did the shitty things, right? So that's uncomfortable for them. Then when you look at the plaintiff, the mediator also will want to speak. Mediator's trying to do two things there. First and foremost, uncomfortable to kind of underscore that litigation and this fight is hard and scary. And even mediation, which is a conciliation process, a process of bringing people together and trying to get them to compromise, is difficult and jarring and hard and emotionally taxing, right? The second thing the mediator is trying to do is trying to make the plaintiff feel that the defendant heard them. This is very disingenuous, of course, because no one who did the bad things is likely at the table. The employer has a representative at the table who's been empowered to make some amount of monetary offer, likely, but you probably don't have the bad actors at the table. So, it's not all that bright that we're like, oh, the plaintiff feels heard by the defendant. Probably not. It's just not a thing. Now, if your attorney is smart, they'll say, hey, yeah, my client's not going to talk today. I'll do the talking. And the mediator will say, that's not how we do things here. And I'll say, yeah, you're not in charge of how we do things. I have to be here. My client has to be here for our case to go forward. That's why it's mandatory. But I did cross that threshold and I'm here. That's all you fucking get, right? Like they're not the boss. They're the lowest paid mediator imaginable. They're just there. Mark the sheet. I'm here, right? And mediation is a beautiful thing. And as people talk about giving you money, and I have many videos on why you should always mediate, mediation is a great fact-finding process, even if you don't settle your case, but also you should engage in it in good faith because often you can get great settlements in mediation. Mediation is incredible. But don't let them put plaintiff in a corner, right? Nobody puts baby in a corner. Like there's no, I'm not referring to plaintiffs as baby. I'm trying to make a joke there based on dirty. They've been through a lot. So you just don't let the mediator do the things the mediator wants to do. Like your client doesn't have to talk. Your client should not be forced to talk. Unless your client is incredibly outgoing and aggressive and like a great communicator who's not going to feel the interpersonal stress of high stakes litigation. If that's the case, then by all means, let them hold forth. Like that's great, but don't let people pressure your client and force them to speak at a crowded table. It's not valuable. It's not good for your client, and it's not where the money lives. Just don't do it. Then, so that's going to be done. That could take 20 to 40 minutes, whatever. And the mediator's going to say, all right, I've arranged coffee and donuts or like a little spread. Got some cold cuts, some nibbles in 2 separate conference rooms. And I want to break up the parties and send them each their own conference room. And I'm going to bounce back and forth between these 2 conference rooms. And I'm going to start with the plaintiff. As you go, you get your really bad coffee. You get your charcuterie board or whatever it is. And listen, you always know the quality of the mediator. If they're not feeding the parties, they didn't come to play. Like blood sugar kills more mediation because people don't eat before they come very often. And then 2 hours in, they're starving and they're like getting hangry. You're not going to settle a case with hangry parties. Like it's not going to happen. And beyond that, they're like, I just want to go. I'm not going to settle. I want to eat. I'm done. I'm out. And the minute they're allowed to end the mandatory mediation, which might, depending on your program, I don't know what the program of mandatory conciliation you're involved with is, could be an hour, could be 2, could be 3, could be half a day. I don't know. I've seen the whole spectrum.
That's a lot of things to take into consideration because, unless you got some kind of high profile thing going on, you're not about to get no charcuterie and, you're not about to get no fruits and vegetables. You're going to be sitting up there hangry for 6 hours, however many hours until you're like, you know what, I'm done. Mediate, settle it. I had to stop and say that because that very much becomes the feeling is like I just want this to be over. Whatever is not going right, and that's why a lot of people don't go into mediations or conciliations alone. This is why they go with an attorney. This is unless, like you said, unless you're like really outgoing or you really know who you're dealing with, that is the best way to go into mediation. Make sure you got a snack.
So instantly, if they're not feeding an array of macronutrients to the parties, nothing's getting done. Just complete waste of time. Just nonsense. I've known mediators who are especially shit in this regard, and I have ordered very fine foods for both sides. Like I've just arranged to have it delivered. I've gotten menus and been like, hey, defendant attorney, we've worked together a couple of times. It's been years. We got lunch coming in. It's going to come in from a third party. You don't have to worry. It's not from me. I may not trust me. But here's a restaurant. It's pretty famous. I think you might like it. Here, order everything you and your client want. No limits, please. And then whatever they order, add to it. Just get desserts, get sugars and proteins and fats in them. Make them happy. Make them able to think. Because a thinking person will do the dollars and cents calculations of, I probably ought to settle this case. And it's probably cheaper and better for me to do the right thing today, right? Same thing goes for your client. Don't let your client get strung out and hangry and like rage out and leave. It's not intelligent. Now, I'm going on 14 minutes here. We're still at the hors d'oeuvres. So the mediator is going to come in. Mediator's likely a bad mediator is going to come into your room with the plaintiff and say, hey, okay, so I want to hear from the plaintiff. And at this point, I would say as the attorney, yeah, let your client talk to the mediator, but have made sure that you've prepped your client. Because here's exactly what the mediator is going to do. He's going to try to make your client feel heard, which again is something he tried to do with the defendant. He wanted your client to feel heard by the defendant. Now he wants your client to feel heard by the mediator. That's patronizing. That is a tactic that works at low-end mediations, like small claims and stuff like that. Here, we're mediating hate crimes in the workplace, sexual assaults. Somebody stripped you of your livelihood and your ability to feed your kids and keep house because you dared to complain about disparate treatment in the workplace based on any protected class, right? Like we're not playing with warm fuzzies here. We're not, oh, Cindy took my saxophone on the playground and I'm sad. That's not what we're doing here. This is serious stuff. And generally speaking, feeling heard is insufficient. So it is patronizing and a little bit silly. It is necessary to some extent, like the mediator should listen to your client. That's important. But many of them come in with the idea of like, I just need to listen to this person for X amount of time so they feel heard. It's not how human beings work. That's not how mediation works. Like that's not how any of this works. Like developing a real understanding of what someone's saying to you takes time and active listening and questioning. It is not easy. So a bad meeting, it's like a bad dude on a date. Just tell me everything. Okay, bro. Okay. And so your client's going to talk a little bit. And then almost no matter what your client says, because we're dealing with a bad mediator is going to be like, okay, I hear you. I understand. But I do hear some flaws in your case. I think you're going to lose. So I think you should settle your case. I actually think you're asking for way too much. And I think you should take way less. I think you're in a bad position here. I think your attorney may have inflated your expectations. And I think you should just take less. I'm sitting there like, my guy, the end is nigh. Like, I'm coming for you. Like, but they do that. They do that routinely. And then here's the secret. They're going to say, okay, you guys talk amongst yourselves. I'm going to go talk to the defendants. And they're going to go across that hallway. They're going to stuff some cannoli in their face. And they're going to tell those defendants that they are in so much trouble. This case looks amazing. They could lose millions. They better get their offer up. And you might say, why? Why would they said the exact opposite to the plaintiff? Why had they told the plaintiff to take chump change? And then why are they telling the defendants to pay millions of dollars? Because they don't give a rat's booty about anybody involved. They want to settle your case to improve their numbers and stop working. And they don't care if that is for 50 cents or $50 million. They do not care. Like, you will often hear in the elevator, defense attorneys and plaintiff's attorneys, when their clients are not around, exiting together. Like, yeah, the mediator tell you, you're gonna lose big? Oh yeah. He said we're gonna lose the factory. Yeah. Like we might be foreclosed upon. We could lose so big. And then, you have these conversations, and then the defense attorney's like, so your guy's a liar, huh? I bet the mediator said he'll never prove anything, right? Yeah, that's exactly what he said. He said he can't prove a gosh darn thing, right? I'm trying not to swear. I'm a little worked up because I just, bad mediators do bad things, and they're garbage people. Just garbage.
Bad mediators do bad things. Oh my goodness, it is not a journey for the weak.
For humans. And it's weird because it's a job that's like meant to be really good. Like sitting down and trying to hammer out a compromise about a really bad thing that happened is a beautiful thing. Fundamentally, like that's a beautiful thing. And I guess I can't fault them for being incompetent, but I can fault them for some of the like underhanded tricks they try. Right? Like, there's more incompetent people than competent people in the world. That's just how humanity works. In a given job, 60-70% of the people who do the job are just, we'd be better off if they weren't there doing the job, right? That's just how it works. 30% of people tend to do all the work in any given field. And I don't hold that against a bad mediator. I do hold against them the fact that they have come to this most significant of moments unprepared. They've not developed themselves, their mediation skill set in a way that will let them do right by someone who has suffered horribly. Horribly. Right? So I'm not making videos about good mediators, because good mediators help people and take care of themselves and do great jobs, and you'll know when they're around, right?
Oh, yeah.
They're out there. There's tremendous mediators. But bad mediators, what I would actually say to you, I think the mark of a good plaintiff's counsel and a good defense counsel, if you're at mandatory mediation and if you happen to have a bad mediator, the attorneys might say, hey, we're just going to get together, attorneys, and talk about this. And if the clients agree to that, the mediator might not. And you say that mediator, you can be in the room, but you can't talk. We're done with you. We're on the clock. We're doing the mandatory thing we got to do because the judge said we got to do mandatory conciliation. And we're here. We're engaging in the process, but like, enough of your nonsense, right? And then the attorneys will get together and be like, okay, listen, let's talk. And defense counsel is going to be like, listen, 5-figure case, no chance of it anymore. And the attorney's like, well, that's not going to get it done. And you knew that when you said that. Defense counsel might agree. Might not be able to say she or he agrees, but might agree, right? That's where they are today. That's the authority they have. Doesn't mean they're not going to settle later. Doesn't mean good things can't happen later in the case. It just means today they're at 5 figures. They want to give you 5 figures. And you know that you and your client are not interested in 5 figures. And the client calls the shots. Like the plaintiff's like going to say yes or no. And the defense side, the employer calls the shots. It's not like the attorney's like getting to do whatever she or he wants. They have a client who gives them authority to give you money to settle the case. And they might tell that client, listen, I need $300,000 to get this done. The client might say, I'm here in 20. I'm here in 20 grand. That defense attorney then has to show up to mediation with 20 grand in her pocket. That's all she can give. That's her direction. And she knows there's no conceivable way that any intelligent plaintiff or plaintiff's attorney will take that 20 grand on this case. But that's the day she's got to have, because she's required to go to mediation and her client is dumb. That happens all the time. And it doesn't make sense to rage at defense counsel when they show up with no money. Now, if they're being belligerent about it, if there's things they can do which will make them distasteful to me, but I'm not going to fault them for their client's decisions anymore. I think they should fault me, right? If I have a case that I know is worth, I don't know, we'll call it $300,000 again. And my client's like, I don't want to go with a demand under $70 trillion. Okay, well, there's no damages calculation that could ever be created to support that demand. Also, I'm not positive, but there might not be that much money in the world. Like, these are the conversations you have, right? There probably is $70 trillion. I don't know. But you can like talk to your client endlessly, and your client just might say to you, I don't care about the calculation. I need to demand this much. I saw it in a movie, or I saw it, a worker won this in blah, blah, blah. Okay, well, they didn't collect it. Like, it's not how this industry works. There's a damage calculation. Like there's realities to the industry, right? Sometimes you got to go in and you just got to say, all right, here's the demand.
My bad, y'all. I was muted. So, before I go any further, I definitely want to touch on this video is in terms of employment law, but it's about mediators and mandatory mediation in general. So, so far the key points are, you are in charge. You are the one that understands the other party the best. And should you not choose to engage in mediation, that is absolutely your right, but that does not necessarily mean it's the end of the case. So I wanted to stop there because I think Vincent is going to go into this, but I just wanted to make sure that no matter what the mediation is, if it is mandatory, you always have the right to say that this isn't going to work. And that does not mean that, oh, you don't have a case or your case falls apart or anything like that. I mean, once you say that, okay, I don't want to mediate. I don't want to do this. It serves no purpose for whatever reason, fill in the blank. So you withdraw your case, especially if you have concerns about like the fairness of the process. I mean, it's basically a crossroads. That's what you're doing. You're stopping. You're stopping at a crossroads. You're not necessarily abandoning the destination, which is moving forward with your case in whatever it may be, employment law, harassment, domestic, whatever it is with regard to mandatory conciliation. You're just taking your time to explore your options and make sure that you're on the right path. So, when you, let's say, the mediation didn't work, I don't want to do this anymore. I'm just withdrawing everything. Now, that does nothing for the potential to refile. You know what I mean? It's, again, depending on the jurisdiction, withdrawing your case, that doesn't eliminate your right to file it again later. It's just like, how you're reading a book and it's like, okay, I got so much other things going on. It's kind of like sitting the book down. And whether that's sitting the book down to uh, collect money you need for an attorney, find an attorney, if you're pro se, figuring out how to go forth with the case yourself, that's what a withdrawal is. It's just giving you time to come back to it when you are ready and prepared to continue that case. So, other than, statute of limitations, which is, what you want to make sure, from the first time of the incident to the last time. The last incident is where the statute of limitations starts. So you have to see how that applies to your case and, how long you might have before you refile. But, when you withdraw from your case or when you withdraw, or maybe let's say you get a right to sue letter and you're like, I'm going to withdraw this because, yeah, I'm going to get my right to sue letter and I'll figure it out. Either way, withdrawing it's reflection, it's strategy. It gives you a chance to gather your thoughts, gather your evidence, determine what feels fair. If you do end up, because you probably, usually even when filing an actual legal action, you're still gonna, go to mediation. So it gives you time to consider what feels fair, how you might approach it. It gives you time to explore any alternative dispute options, any maybe a private mediation or arbitration, but it also gives you a time to really prepare your case and the points of the case, because in mediation you're going to be talking about what it is that you want out of that situation, regardless of what the situation is. You're going to be talking about what it is that you want. For example, domestic violence. I want this person that, I'm been in a relationship with to stay away from me. If it's a stranger, I want this person that I don't even know to stay away from me. That's just one of the things I'm asking for. I'm asking that they pay me $100 for the damage caused. You have to be clear on what you want when you walk into mediation, because mediation is not a time to talk about, oh, all these things that happen to you. It's a sometimes usually a set amount of time for you to express what you feel would be fair. And so, withdrawing your case to take that time to do those things, that definitely doesn't mean that you're waving goodbye to your pursuit on a resolution at all. It does not mean that. Actually, it's a more strategic pause, because you can reevaluate your options, that way you can ensure that you're moving forward in a way that aligns with the goals, values, what you're trying to get out of it, what is your end goal, what is your end result. But I just wanted to put that in there because a lot of times mediation, going through it, doesn't work out. Sometimes, depending on, I'll just take employment law for example. you know uh, Once, I think it's like before an investigation really kind of gets started, it's like everyone's notified, and then there could be an offer for mediation where you can say yes or no. No, I want to investigate, or yeah, let's try the mediation now. It's just, from my experience, it's much harder to try to mediate when you're at two different ends of a stick, so to speak. It's like you want to. Sometimes you won't be able to come together, and that and sometimes there are some extenuating circumstances involved, but those are the times that you might, or one might, want to withdraw their case and make sure that they have their ducks in a row, because there could be things ongoing that is retaliation that could stem from other things. There are just so many nuances when it comes to withdrawing from a case. But I want to let Vincent White continue, because I think he's almost done here.
It is what it is. And then the mediator and the defense counsel can be like, how do you calculate that? I refuse to answer questions about my calculation. And everyone just looks at you like, okay, so it's not something you can support with facts. Okay, right? And that's the gig. Clients are the shot callers. They're in charge. You can give them all the advice you want, but that's what you enter the mediation with. I will say, even a bad mediator can be really valuable to sit down and be like, hey, so you went with this demand, and your attorney's refusing to tell us how you calculated it. Can you tell me how you calculated it? Because I have a lot of the formulas for how damages are calculated. Side note, there's a playlist on this channel with a lot of videos about how to calculate your damages. Really valuable if you're trying to get ready for mediation. But plaintiff, like, your attorney won't answer how you got to $70 trillion. Will you tell me? And the plaintiff will say something, and the mediator will say, yeah, but you were in 18 grand a year. So you would have to work infinity years, just about, not literally, but just about, to get $70 trillion. And like, your emotional damage, you're not treating, and the things that happened to you, they were wrong, they were bad. There's no physical touching, there was no physical threats, you didn't have any physical symptoms of anxiety, like, in terms of emotional damages, not the top tier evaluation or seriousness in terms of the emotional damages. So do you see what I see, plaintiff, that your number has no anchor in reality? And that's something even the worst mediator can do. Like, if they're brave enough to just have that conversation and be there for that conversation, let the plaintiff lose her or his mind on them, that's really valuable. And it's one of the things that's valuable about mediation. Mediation, you should go. It's going to be people talking about giving you money. You can learn a lot about the other side's perspective on the case. You can kind of, to some extent, anchor them to some number that they can't really go down from. Videos on this. But also there's a process of like, hey, you know that people outside of you, plaintiff, will have input on this number. Like, you can say any number you want, but when you sell a car, you don't think about how much you want. You think about how much it's worth, right? The question isn't, oh boy, how much money would I like to have when you sell a car? The question is, how much do you think I can get for this car? And those are two very different questions, because one is just a statement of desire, and the other is anchored in fact. It might not be correct, but you're using data and information to calculate a number as to what you think you can get for this car you're trying to sell. And if you're trying to settle a case, you are in fact also going to have to think about, well, if I look at the facts and if I look at how damages are calculated, and if I look at the reality of this situation, what can I actually get for this case? And also, how do I adjust for risk if I go to trial, right? Like, that's valuable. We have a lot of videos in that. I'm going way too far. I'm at 26 minutes. Listen.
It was so very helpful, Vince. We thank you so much for your commentary. Now, what I did want to add was, he talked about a lot about monetary damages, and sometimes when you are in mediation, you have to think. You have to think about non-monetary damages as well. So that's one of the other advantages of, if you are not ready, because part of it would be client well-being. If you are not ready for the pressures of mediation, and or it just doesn't work out, you also have to think about what non-monetary damages would look like. Does that look like a formal apology letter? Does that look like a statement clarifying something? Does that look like, if it's a job, getting your job back? Does that look like getting a reference for a job? Just depending on the case. Domestic, what someone, in the process of a domestic incident, the door was broken, that was $500, but what else are you asking for? Are you asking for this person to stay away from you? It's just so much that goes into mandatory mediation. Even I would think that good mediator or bad mediator, I feel like there is pressure for people going in, especially pro se litigants. And I'm sure there's pressure for people that have lawyers. But it's just really important to know that whatever you decide to do for yourself, hopefully you don't come across any type of situation where you would need something like, this level of mediation. But unfortunately, too many people have, on so many different levels: employment, family, community. Unfortunately, people have gone through that, and they have not been able to get a sense of justice even in those spaces. So I hope this was helpful, even if it was just for one person. I hope that this was pretty helpful. I just, again, want to reiterate that, if you decide to stop your case, or if you do a motion to dismiss or withdraw, that is not a bad thing at all. It actually provides new opportunities for resolution. You don't have to just jump into the litigation process because that is so stressful. You get time to explore your options for negotiation before fully committing to the next steps, which is, if you're going to refile, you get to think about that before fully committing to that next battle, because those legal battles are tiring. They are so tiring. And let me think. It gives you time to make strategic decisions. This is where you have the opportunity for you to assess and reassess what your approach is. Again, what's your end game? You know, what what do you think would work, and what do you think would work with the person or people sitting across the table from you? What are your goals moving forward? What did you lose? What do you need to gain? It's a chance to refine your strategy so that you don't end up with having to correct paperwork later in court and things like that. It's not a bad thing to either withdraw a motion to uh, sue someone. It's not a bad thing to withdraw a case. Again, because let me say, I want to make sure I get everything out, because I'm going to end this up in almost an hour, and I did not expect that. Let me see. Oh, it gives you an option to, especially if there's some type of retaliation or whatever it is. I'm using the word retaliation because I'm thinking more of employment law. So, um, if there's more retaliation, now you have time to uh, put all that stuff in. You have time to um, up the ante on negotiating uh, a resolution, and it's kind of like creating balance between that fear of falling, like if you're walking a tightrope, like that fear of falling, and that desire to reach the other side, which is the end, which is the settlement or the lawsuit or the win, or just to have it be over. But it's more important to take care of yourself. It's more important to do what feels right. And then, once you've taken the time to do what you need to do, if you do decide to proceed with any litigation, just know that you're stepping into a different arena. And, it's formal rules, procedures, and that's where those timelines come into play again. So, if you are taking your time to decide what to do, the main thing to do is make sure that, you never pass up what the statute of limitations may be in whatever your case is. And just remember that, whatever you decide to do with your case, whether you have a right to sue letter, whether you have withdrawn a case, it's not the end of the line. It's actually a new beginning. Sounds crazy, right? But that time in between offers you a chance to look at all actions. Maybe the actions of people have expanded since you first tried this. So now there's a lot of things, a lot of a lot more moving parts, I should say. So we just never know, and we should know. It's definitely our right to know what we're getting into if we move forward with anything regarding the law. So I just feel like it offers a chance. Once you take a break, you can pause, reflect, and then you can decide the best course of action moving forward. So, I don't know. It's just, I always say, if you don't know that, if you don't know exactly what you're doing or how to navigate the legal system, it is best to get a lawyer, which costs money. Everyone's not going to do something on a retainer agreement. But again, that's where, you get to take that strategic pause and you get to reevaluate your options and just ensure that you're moving forward in a way that aligns with your values and what you can live with in the future. So that was my awfully long-winded take on the truth about mandatory mediations. Those mediators are just trying to get you up and out. They're trying to get your case settled because it's numbers for them. And that's, I'm not going to say it's good or bad. It is what it is. And until next time, of course, I am always sending you love and light. I really appreciate everyone being here. And until next time.